Welcome to this explainer. Today we're going to dive deep into the fascinating legal architecture of a Hindu marriage. We'll be unpacking the real core of the Hindu Marriage Act of 1955, specifically sections 5 through 8. If you've ever wondered exactly where the lines are drawn between ancient, long-standing traditions and modern statutory law, or how just one missing ceremonial step can literally invalidate an entire union, you are definitely in the right place. We're going to break down the foundational rules that dictate what makes a marriage legally bulletproof, what makes it kind of problematic, and what makes it completely unrecognized in the eyes of the law. Here is our roadmap for today. First, conditions for a valid marriage. Second, age and mental capacity. Third, customary ceremonies and rites. Fourth, judicial reality checks. And finally, the registration mandate. All right, let's start right at the threshold. Section 1, Conditions for Valid Marriage, which is governed by Section 5 of the Act. So before we even look at a wedding ceremony, Section 5 acts as the ultimate gatekeeper for capacity and status. First up, monogamy is strict. If either party has a living spouse, or if they fall under prohibited subhynda relationships, meaning they are just too closely related by blood, the marriage is legally void. But there is a massive custom override here. If you can prove a long-standing custom that permits marrying specific relatives, that custom legally overrides the statute. But to prove it, the custom has to pass 4 strict legal tests. Antiquity, meaning it's age-old. Certainty, so it's clearly defined. Reasonableness, meaning it's not opposed to public policy. And continuity, meaning it hasn't been abandoned. On the flip side, issues like mental capacity or being underage don't make a marriage void. They make it voidable. Now, we really need to nail down this distinction right away because it is absolutely crucial. What is the difference between void and voidable? A void marriage essentially never existed. In the eyes of the law, it is null and completely invalid from the very beginning. A voidable marriage, however, is fully valid and legally binding right up until the exact moment it is formally and successfully challenged in court by one of the parties. That one distinction is literally the engine driving a massive amount of family law litigation. Moving on to Section 2, Age and Mental Capacity. Let's see how that void versus voidable dynamic actually plays out in real life. When we look at the mental capacity requirements, the law doesn't just slap a blanket ban on anyone with a mental illness. It gets highly specific. It lists conditions like an unsound mind, lunacy, and congenital idiocy, along with periodic or recurrent attacks. But here's the critical legal filter you need to remember. Just having one of these conditions isn't enough to invalidate the union. The key condition here is that the mental disorder must actively render the person unfit for the duties of marriage or for the procreation of children. Only then does the marriage become voidable. This is to stop opportunistic partners from using manageable, everyday mental health struggles as a cheap exit ticket from their marriage. To really see how courts apply this, we can look at the case of Alka Sarma versus Abhinesh Sarma. In this specific dispute, the court firmly cemented that threshold rule we just talked about. They reiterated that mental disorders only impact the legal status of the marriage if they meet that high standard of making the party unfit for marriage or procreation. It's a deliberately high bar designed to protect vulnerable individuals. And let's look at how this applies to age requirements. Take the fascinating 1978 Venkatarama case. A 13-year-old boy was married to a 9-year-old girl. Years later, the husband took a second wife, and the first wife actually filed a bigamy case against him. But remember our blueprint? Underage marriages are voidable, not void. Because that first child marriage was never formally annulled by a court, it was still legally considered a valid existing marriage. So the courts basically had to navigate this incredibly complex dynamic where a child marriage served as the foundation for a legitimate bigamy charge. Of course, the law has evolved to address this, though it keeps that core framework intact. Under the Prohibition of Child Marriage Act of 2006, Section 3 deliberately keeps child marriage legally voidable rather than entirely void to protect the rights of the children involved. But to actually stop the practice, Section 9 brings the hammer down. It punishes the act of facilitating a child marriage with up to 2 years in prison and a fine of 1 lakh rupees. So the marriage might stand legally if unchallenged, but making it happen is a very serious criminal offense. Let's move to Section 3, Customary Ceremonies and Rites, governed by the all-important Section 7 of the Act. The Hindu Marriage Act is honestly pretty remarkable because it doesn't force a single, uniform wedding ceremony on everyone. Instead, Section 7 powerfully defers to custom. It clearly states that a marriage may be solemnized in accordance with the customary rites and ceremonies of either the bride or the groom. The state essentially steps back, folds its arms, and allows community tradition to define the exact moment a marriage comes into existence. It's statutory law giving the ultimate power to ancient tradition. However, if the chosen custom happens to include the saptapadi, which is the traditional taking of steps around the sacred fire, the law gets incredibly precise. It states that the marriage is only legally complete and binding the absolute moment that this seventh step touches the ground. If you stop at step 6, in the eyes of the law, there is no marriage. It's that strict. And this beautifully reflects the diversity recognized by the Act. The law formally validates a wide array of rights like the Sikh Anand Karaj and the Jain Mangalpara. State amendments have explicitly broadened this too. For instance, Tamil Nadu and Pondicherry officially recognize Suya Maria Thai and Sirtaruta marriages, often known as self-respect marriages, which completely strip away traditional priestly rituals. This perfectly aligns with what the courts established in the famous Gopalakrishna Nayars versus State of Kerala case. That case highlighted the comprehensive expression of Hindu identity, acknowledging that diverse regional rights are equally protected and fundamental to defining who falls under the jurisdiction of the HMA. Let's transition to Section 4, Judicial Reality Checks. How do the courts actually interpret these customs? Because courts definitely don't just accept any random practice. They apply strict legal tests. A key precedent here is Rama Lakshmi versus Sivanatha, which established the certainty condition for customs. A custom must be clearly defined and consistently followed. If there's ambiguity, it fails. We see this play out in the 1954 Daveen Achi case. The parties claimed they were married just by exchanging garlands in front of some friends. The court examined this and firmly ruled it did not constitute a valid legal marriage ceremony. It was just too ambiguous, lacking the certainty and continuity of an established custom. Things get even wilder in the Ramsaran versus Mahabir Sewa case, where a marriage was allegedly performed with a kshatriya's sword. Remember the Raja Varma versus Rabi Varma case that established the reasonableness test? Even if a practice is ancient, if it defies reason, public policy, or modern legal standards, it cannot be upheld. So the court flatly rejected this sword marriage as legally invalid. And this isn't just theory. It had tragic consequences. Because the marriage was invalid, the children were deemed illegitimate and completely lost their claims to family property. But conversely, look at the 1950 Inner Panaswamy case. Here, the essential ceremony involved tying a tali in the presence of a temple idol, but there was no actual temple priest there to officiate. The court looked at the custom and held that this was indeed a perfectly valid form of marriage. The absence of a priest didn't invalidate a custom that passed all the tests. And because it was a valid first marriage, when the husband tried to marry again, he was successfully hit with a bigamy charge. Breaking away from procedural technicalities, the courts also use these cases to address major social barriers. In the 2006 Lalita Singh case, the Supreme Court strongly validated intercaste marriages. And they didn't just rule on the law, they delivered a profound social critique, directly stating the caste system is a curse on the nation, dividing the nation. It's a powerful reminder that the judiciary relies on these marriage laws not just to enforce ancient rights, but to fiercely protect an individual's right to marry across traditional social divides. Finally, we reach Section 5, the registration mandate, governed by Section 8 of the Act. Section 8 outlines that the state government is responsible for facilitating and maintaining a public marriage register. But listen to this because it's the most vital takeaway of this section. Failing to register your marriage does not legally nullify it. Failure to follow registration rules will absolutely not render the marriage void or voidable under the Act. If you completed your valid saptapadi or customary rites, you are married, paper or no paper. That being said, the Supreme Court eventually realized that a lack of registration causes massive administrative and legal headaches down the line. As we see in the landmark 2006 Seema versus Ashwani Kamar directive, the court emphasized that marriages are a crucial part of a state's vital statistics. To fix the messy record-keeping, the Supreme Court directed all states to notify registration procedures within 3 months and appoint specific officers to handle these registrations. And to give this directive some actual teeth, state governments were empowered to make marriage registration compulsory. If you ignore it now, it can seriously hurt your wallet. Non-compliance can carry a hefty fine of up to 25,000 rupees in some places. So while skipping registration won't legally undo your marriage, it is treated as a very serious administrative violation. We can see exactly how this works in practice by looking at state-level execution. Take the Tamil Nadu Registration of Marriages Act of 2009. Newlyweds are put on a super strict timeline. Under Section 5, Subsection 1, you have exactly 90 days from the date of the marriage to complete your standard registration. Miss that window?
You're granted a 60-day grace period, capping out at 150 days. But that extension is only permitted if a late fine is paid. The state wants its records.
As we wrap up this explainer, we've seen how the Hindu Marriage Act intricately balances centuries-old rights with modern statutory regulations. A marriage's validity really hinges on a complex web of legal capacity, rigid custom, and judicial interpretation. So I'll leave you with this final thought to ponder. When ancient traditions meet modern statutory fines, where does the true power of a legal marriage actually lie? Is it in the seventh step around the fire, or in the stroke of a registrar's pen? Thanks for joining me on this deep dive.